Hey everybody, thanks for joining me. Today I want to talk about the 3 different tools that courts use in order to determine custody and parenting time in New Jersey. Now, you may have seen my other video called the 7 S's of custody and parenting time. If you have not watched that, then definitely watch it once I'm done, or once you're done, I should say, watching this video, okay? But those are the factors. I want to really talk about the devices that the courts use. And there are 3 primary devices of varying usefulness. All right, one is called a custody neutral assessment, which is a total waste of time. Okay, one is called a Guardian Ad Litem, and maybe you've heard that term. And another is called a best interest evaluation. Okay, so this is how lawyers actually will litigate these motions or these divorces, whether it's a motion or a divorce. These are the tools that lawyers will use to show why the factors weigh in their favor. All right, this is a kind of complicated subject. I'm almost reluctant even to do this video, except I think a lot of people just don't understand this sort of thing. And so I'm just going to do my best to try to explain it all. All right. A custody neutral assessment, which is just completely useless, is when you have someone from the court will interview the husband, interview the wife, and just try to figure out what their various positions are as far as custody and parenting time. So husband says, well, I should be spending 50-50 parenting time with the 2 oldest kids and, 1/3 parenting time with the youngest child, or whatever the numbers are. And the wife says, no, it's something else. All right, so the custody neutral assessor will simply write down husband's position, write down wife's position, put it on a piece of paper and give it to a judge so the judge sees what the issues are. It in no way advances anything. It's a complete waste of time and money. You can just do that yourself, or your lawyer can do it for you. There's no purpose to it. All right. I really want to instead focus here on the Guardian Ad Litem, or you might hear called the GAL, right? Guardian Ad Litem, or the best interest evaluation. Now, these are 2 very different things, but I've noticed that they're used interchangeably. All right. The best interest evaluation is when you hire an actual child psychologist and they do a serious investigation into the parents, into the kids, into the schools, maybe even their friends. What are their activities? What do other people have to say about this? And they write this lengthy report, 30, 40, 50-page report of these various interviews and the various findings and what they think is in the best interest of the child. And it's really, really detailed stuff. And you think, well, this is great, right? Well, first of all, this is extremely expensive. All right. There are only a handful of people who do these things. All right. You can expect to put out $12,500 to $15,000 for one. And maybe you want to split the cost with the person you're divorcing, and maybe they want to get their own person and you want to get your own person. And then we have this battle of expert witnesses. All right. But this is something the courts are going to weigh very heavily. If you've got an expert witness in the form of a child psychologist who says, I've done all the work for you, judge. Okay. And the judge's word is final, but they're going to defer to this heavily. If you've got an expert that says, I've done all this work and here's what I think should happen and here's why I think that should happen, then that's gonna weigh very, very heavily, almost to the point of being dispositive. Like if you've got a best interest evaluation and your ex doesn't and it's in your favor, good for you. I mean, you're pretty much going to prevail. Again, it's expensive and there are only a few people who do these things and they are really backed up. I mean, from the point that you ask for a best interest evaluation to the point you get one, you can expect it to be like 9 months. And by the time you get that, and by the time you get it in front of a judge, and by the time you have your hearing, maybe it's a year or more, and maybe the best interest evaluation by then is stale, right? Because kids are getting older. Maybe they've gone into high school now from 8th grade. Maybe they started school now when before they weren't even in preschool. And so things change. Maybe your work schedule has changed. So these things are expensive and they're kind of hard to work with sometimes because it's a very slow process. And by the time you get it, now things have changed and now maybe the other side wants to get theirs. So I don't want to say too much bad about it because it's a good thing if it's in your favor, but you have to understand its limitations. Now, to get around those limitations, some courts, and I don't agree with this, but this happens, have fallen in love with this thing called a Guardian Ad Litem, okay? The big difference is a Guardian Ad Litem is supposed to be an attorney who represents the children and therefore represents their interests, okay? A best interest evaluation is a psychologist who is remaining neutral. They're trying to find out what is in the best interest of the child, though. And presumably a Guardian Ad Litem who represents the interest of the child is also trying to advocate for the best interest of the child. But the weird thing about it is an attorney, I mean, I'm an attorney, obviously, but attorneys aren't psychologists. And so what's happening with these guardian ad litem things is courts are using them instead of the best interest evaluation because they can be done more quickly, okay? But then they're kind of deferring to the findings, even though an attorney really isn't qualified in the same way a child psychologist is to make findings and recommendations. I mean, yes, you can make findings of fact, but then to turn that into a recommendation is something else entirely. And I've, been in situations where certain judges just fall in love with these things because they're basically outsourcing their judicial fact-finding responsibility to an attorney, to another attorney to play like junior varsity judge for them. And it's quicker because there are tons of lawyers as opposed to only a few child psychologists who specialize in this sorts of thing. And it is less expensive, but it's not the same thing, even though it's being used as the same thing. The guardian ad litem, in my opinion, should really be limited to situations where there are credible allegations of abuse, in which case DCP&P is involved. And the child really needs somebody to speak on behalf of itself, on behalf of himself or herself, okay? To use it as a substitute for a best interest evaluation, I don't really think that's appropriate. Again, that's just my personal opinion. Sometimes they're used to great effect, especially if they give you a result that you're happy with. Sometimes I can tell you it's appropriate if you've got a child who wants to express an opinion as to which parent they want to be with, but courts don't really want to bring kids in anymore, right? They used to kind of do that more where the judge would actually interview the child in chambers. Sometimes if the child really is able to articulate their position, the best way to do it is through a guardian ad litem. But again, I think it's inferior for a lot of ways, for a lot of reasons, to a best interest evaluation. But there are definitely times when it's useful and definitely times when it's better than the alternative. Every case is different. And I don't mean to dump on the guardian ad litems, many of whom I know personally, and they do good work. I'm just saying they are not always a suitable replacement for a best interest evaluation. Now, why are we even talking about these things? Right? Shouldn't it just be that like you present your evidence to a judge and they present their evidence and the judge weighs the evidence and makes a decision? Yeah, it should be like that. But here's the thing. The courts are overwhelmed. They were before COVID. It's way worse now. Okay. And judges, where they can take these shortcuts, and I'm not dumping on judges, but I'm just explaining that where they can take these shortcuts and where they can have some other professional do a lot of the investigation and a lot of the fact finding, a lot of times they're going to defer to that. And knowing that means that most of these cases don't even wind up in front of a judge, because if you've got a good best interest evaluation, usually that's what gets deferred to, because everyone pretty much knows that unless there's something ridiculous in there, the judge is going to place great weight on that. Again, I'm not here to dump on judges. The judges are smart. They have difficult jobs to do. I'm just trying to impress upon you that this is a human practice, and it just seems like a lot of the fact finding is getting outsourced. All right. It's almost like in the federal courts, how they have a magistrate before you get to a judge. It's sort of like a sub judge that does a lot of the other work. A lot of other people are being asked to make findings of fact to then present to the judge in a nice, neat little package so the judge can just review it easily. And I think it sort of short circuits the process. Okay. Right or wrong, I'm just telling you how it is. So all of which is to say this. If you haven't seen my other video called the 7 S's of Custody and Parenting Time, go watch that video. It's important for you to understand what the factors are. But this is really more about the mechanics. Once you know the factors, this is really how courts take those factors and mix them together and how you get a result. Okay. So if you've watched this video and you're in a custody battle or you think you're going to be, go ahead, give me a call. I'll talk to you about the situation and we will map out individually what we think is the best way to go about it, depending on your individual circumstances, whether that means a guardian ad litem, whether that means a best interest evaluation, whether that means we simply negotiate a position, any of those three things, we'll discuss what we think is best. Again, custody neutral assessment, total waste of time, total waste of money. Don't bother with it. But there are other alternatives, is my point. Negotiation, mediation, that sort of thing, the best interest evaluation, the guardian ad litem, and we can talk about all those things if you'd like. All right, guys, thanks for watching. Take care.